All right, here we go. Chapter 11 for this week, the trial procedure itself. Bad guy's been caught. Good job. Great work. The district attorney has prosecuted the case. Awesome. Wonderful. There's enough evidence to move forward. And now it is in the process to determine the guilt or innocence of the individual. So, the trial itself, the definition is a procedure to determine if the prosecution can prove beyond a reasonable doubt that the accused committed the offense with which he or she has been charged with. So that means no matter what, beyond a reasonable doubt, this is the individual who did it. The rules governing the trial procedure are designed to provide both the government and the accused with a fair trial. Again, everything goes towards the accused and the fact that they have a fair trial. All right, opening statements. This is an opening statement. If you guys ever get a chance to watch the Hernandez story, the rise and fall of this famous football player, 23 years old, millions and millions of dollars to play a game, and how he ended up being a murderer. It was amazing fall from grace story. Prosecuting attorney has the opening statement. The prosecution goes first because they have the burden of proof. It's upon the prosecution to make sure that the proof is met if the person is going to be found guilty. So I want you to watch this video here. Tell me in your opinion what you learned from watching the video, okay? Prosecuting attorney's opening statement. The prosecutor has considerable latitude in referring to the evidence that he or she plans to introduce during trial, but the statements are not considered as facts of the case. So, like, let me give you an example of what one of my cases, a gang case. It could be a gang case where there were 6 defendants, and during that time, we arrested all 6 defendants. I was sitting at the table. The prosecution starts the opening case that these 6 individuals are all known gang members. Name the gang, because different gang members do different crimes all the time. And we're going to establish the fact that the gang members worked together in concert to benefit the gang. Therefore, we're going to determine the gang enhancement, charges against the individuals, and during the course of this investigation, you'll be hearing statements that were taken from the telephone due to a wiretap. You will be shown video outlining where the suspects drove by in their car, hung out the car, and shot at the victim several times. We will bring forward the guns that were used in the case. You will see the bloody clothing from the victims to show where the bullet holes penetrated the bodies, or whatever you're going to show, okay? So, and you outline the reason why you believe that the suspect did this, all right? And then, of course, the defense has an opening statement. So, I hate sexual predators, cannot stand them. So, this woman here was videotaping herself having sexual encounters with a 4-year-old. I don't believe it said boy or girl. I want to say it said boy, but I did not commit that to memory from watching the video. So here she is having sexual encounters with a 4-year-old toddler, right? So we arrest her. You guys go out there, do great work because she's wanted, right? And you guys are great detectives. You go out and find this pervert and bring her to justice. So now, even though she's got all this video of her having sexual encounters with a 4-year-old, they still have innocent until proven guilty. Even though there is videotape of her having sexual intercourse with a child, right? So everybody has got this. We live in America. Everybody's afforded this great thing where you're all innocent until you're proven guilty in a court of law. It's even though there's videotape of it, you're still innocent, okay? So, even though, tell me your thoughts. Again, this is your opinion. I want you to watch this video. And even though it's on video of this woman having sexual acts with a toddler, what your thoughts are if she's still innocent until proven guilty, even though they caught her on videotape, right? I want to know your thoughts, so it's part of the assignment. The U.S. Supreme Court has held in a number of cases proving a criminal charge beyond a reasonable doubt is constitutionally required. Constitutionally required. Okay? And witnesses. The defendant is entitled to confront the witnesses against him or her. Now, unless the actual defendant is the one that's representing himself, it's the attorney who's going to ask the questions of the witnesses who come forward and said, yeah, I saw Johnny or Sally do this horrible crime, and this is what I saw. And so the attorney is allowed to ask questions. Well, you say you saw my client. Is that true? Do you wear glasses? How far away from you during the crime? Was there any other obstructions? Have you ever seen my client before? Do you know them personally? All kinds of questions that they're going to ask during this period, okay? Subpoena is persons who are officially required to appear in court, and they will receive a subpoena. If you do not follow up with a subpoena, you can be found in contempt and you can go to jail. So occasionally a witness will be commanded to bring any books, papers, documents, or other physical evidence known as a subpoena dusum tecum. Witnesses failing to appear, like I said, may be held in contempt, excluding any or excluding other witnesses during the course of the trial. So I want you to watch this little video here and tell me 3 things you learned from watching that video. Examination of the witness under oath or affirmation that the witness is going to tell the truth, whole truth, nothing but truth, so help you God. A lot of people got rid of that, so help you God. And Jolene Gonzalez's own opinion, I think that's where a lot of things started crashing. But they have direct examination of the witness themselves, and the question of the witnesses by the side that calls him or her is the direct examination. So you have witnesses for the prosecution who's trying to determine the guilt of the individual, and the defense attorney is trying to determine the innocence of their individual. So whoever calls them on their side is known as direct examination. Oops. And watching this little video here, I want you to tell me 3 things that you learned watching that video. Objection to questions. So if a question is asked on either parties, whether it's on the prosecution or the defense, both attorney has the right to object. You hear it on TV, I object, meaning I don't want this question answered of the witness or whoever's on the stand at that time, and the reason for the objection, okay? Cross-examination enables the opposition or adversary to challenge a witness' veracity, accuracy, and prejudice. So whatever the questions that were asked at the prosecution side, you can ask all these questions. The defense now is allowed to ask their questions and find out whether they can get you to change your mind or made you have any doubt about the questions that you just answered on the other side. Refusal to answer questions. A witness must answer all questions during court. If not, what can happen? I want you to tell me what can happen. Make sure you read your book or let me know. Your thought process. I don't want the actual text. I want you to know by reading it and tell me your interpretation, what you're reading. Examination by the judge or jury. Witnesses may also be called by the trial judge if deemed necessary in the interest of justice. So if you're not having a jury trial, the actual trial judge can call witnesses and find out what's going on. All right. Introduction of physical evidence can be brought forward through the witness. So say you're a witness to a crime. You're in your local Stop and Rob 7-Eleven. Bad guy comes in and he is shooting up this place, right? You're there. You run to the back by the Slurpee machine and take refuge there till it's all over. And now you're a witness to the crime. So when you go into the trial phase of this court system, they're going to ask you where you were standing. They'll show you a picture, right? Now here's a picture of 7-Eleven, Johnny or Sally. Please tell us where you were standing prior to the robbery suspect coming in. Oh, I was standing right here. Okay. So what did you see? Did you see the defendant here? And it's amazing how the defendant can look like a total scumbag the day of the crime. And when he's in court, he's got a suit and tie on. He's all clean shaven. And sometimes they look like the attorney. So clean shaven. I'm like, looking at this gang member that I arrested, I'm like, the guy's a thugged out gang member. Now I'm looking and he looks like an attorney. He's all clean cut, sitting there, right? writing with his paper. I'm like, we can't even write a sentence. Give me a break. So anyway, they'll tell you, they'll go through it and they'll bring evidence up and just say, do you recognize this gun? And here's a photograph of the gun. Demonstrating the evidence is shown here. Johnny or Sally, is this a gun that you believe to be used during? Oh, yes. How do you know that? Because it's got a beautiful heart shape on it or whatever the case may be, okay? So once all the evidence is out on the prosecution, they think they have enough evidence out there to determine that beyond a reasonable doubt the defendant did it, they rest. Done, we're over. And then at that time, the defense can end up bringing up some more witnesses, and at that time they have the judgment of the acquittal. All right, so, there we go. We have a video here. Let's watch this little video here, and I want you guys to tell me your understanding of the evidence presentation system. Not 3 things you learned. I want you to tell me what your understanding of the evidence presented in court, what that means, okay? So again, now the defense approaches because the prosecution rests, and it's up to the defendant to decide whether they're going to testify or not. I got to stop here and chop this up, and we'll continue in the next module. All right, hang tough till the next module.